What is a mercenary under IHL? Have you ever wondered what exactly defines a mercenary under international humanitarian law? This topic is quite fascinating and important, especially when we think about the roles of different actors in armed conflicts. Let's break it down step by step. According to Article 47 of Additional Protocol I to the Geneva Conventions, a mercenary must meet 6 specific criteria. First, the person must be specially recruited, either locally or abroad, to fight in an armed conflict. This means they are not just regular soldiers but are specifically brought in for combat purposes. Second, the person must actually participate directly in hostilities. This means they are not merely support staff or observers, they are actively engaged in fighting. Third, the motivation for becoming a mercenary is primarily private gain. They receive material compensation that is significantly higher than what combatants of similar rank and function in the armed forces of a party to the conflict would earn. Fourth, a mercenary is not a national of a party involved in the conflict, nor are they a resident of territory controlled by one of the parties. This is key because it distinguishes them from regular soldiers who are part of their own nation's military. Fifth, they are not members of the armed forces of a party to the conflict. This means they do not hold any formal military position within the armies involved. Finally, a mercenary has not been sent by a state that is not a party to the conflict on official duty as a member of its armed forces. This last point further clarifies their status and role in the conflict. It is important to note that this definition applies strictly to international armed conflicts. The status of a mercenary must be determined by a competent tribunal of the detaining power. Unlike lawful combatants, mercenaries do not have the right to combatant or prisoner of or status under international humanitarian law. However, they must still be treated humanely according to the fundamental guarantees of humanitarian law. From the perspective of the Geneva Conventions and the laws of armed conflict, mercenaries occupy a unique legal category. They do not receive the same protections as lawful combatants or prisoners of war, but their humane treatment is mandatory. Interestingly, being a mercenary is not a specific crime under international humanitarian law or the Rome Statute of the International Criminal Court, although some national laws may criminalize mercenarism. The International Convention against the Recruitment, Use, Financing and Training of Mercenaries expands this definition. It includes individuals recruited to participate in acts of violence aimed at overthrowing governments or undermining constitutional order or territorial integrity, motivated by private gain and not officially sent by a state. When we look at private military and security companies, or PMSCs, mercenaries differ in that PMSCs often operate under contracts. They may be subject to different legal frameworks, such as the Montreux Document. This document outlines state obligations and good practices for PMSCs during armed conflict. PMSCs may provide military or security services, but do not necessarily meet all the criteria of a mercenary under international humanitarian law. In practical terms, distinguishing mercenaries from other non-state actors or private military personnel is essential for applying international humanitarian law rules. This is particularly relevant regarding the protection of civilians and the lawful conduct of hostilities. Mercenaries, driven mainly by profit and lacking formal ties to a party's armed forces, present challenges for accountability and compliance with humanitarian law during conflicts.